Your Honor, thank you for the opportunity for rebuttal. We are not here today to discuss the merits of plaintiff's claims against my client or the facts that may support them. We are here today to decide if arbitration is an appropriate forum to resolve the parties' dispute. And the response is yes, the parties have voluntarily agreed to bind themselves to arbitration. As you heard from opposing counsel, the parties are not in disagreement that the contract between Mr. Jennings and my clients is valid and enforceable. More importantly, opposing counsel also confirmed that the plaintiff is not challenging the validity of the arbitration clause. Therefore, the party opposing arbitration has the burden of proving that the dispute is not within the scope of the arbitration agreement. And I believe that the plaintiff has failed to do so. Jennings believes that the dispute is not subject to arbitration because 1. A contractual precondition to arbitration was not met, and 2. The subject matter of the complaint is against social or public policy concerns. Let's talk about the first argument. All preconditions of the employment agreement between Jennings and Chaos Holding Corporations have been satisfied. The contract under Section 9 recites in part that the parties shall try to resolve amicably any disputes they may have. If the parties are unable to do so, then the parties agree voluntarily to subject their disputes to binding arbitration. The precondition was met because prior to Jennings filing the complaint, Jennings reported his beliefs to management and HR. Meetings took place and certain actions were taken. Mr. Jennings' dislike of the outcome of those attempts, but the fact that he doesn't like how those attempts to try to resolve the dispute failed are not grounds to support a claim that a contractual provision was not met. The contract agreed by the parties only says that the parties shall try, and the parties did try to resolve the conflict in a manner that they deem appropriate at the time. Right or wrong is not the point of this argument. The point is that the parties did try through several actions to resolve this dispute, and it didn't work out. So the contract calls that the next step should be binding arbitration. In Moses Cone Memorial Hospital v. Mercury Construction, the Supreme Court has enunciated a liberal federal policy favoring arbitration agreements under the FAA. The court reasoned that the courts handling questions about whether issues in disputes are arbitrable under a particular arbitration provision should always favor arbitration. So in this case, even if there's a doubt, the wording of the contract only calls for the parties shall try, and the parties did try. Therefore, because the condition was clearly met, there is no ground under this argument to refuse arbitration. On the second argument regarding public policy, opposing counsel is correct that the traditional view has been that conduct involving the government regulation of commercial activities, such as conspiracies to fix prices, should not be arbitrable because it is so intertwined with the larger social interest. The plaintiff has made allegations under both state law, such as the Minnesota Whistleblower Act, and federal law, the Robinson-Putnam Act. State law is not appropriate to discourage arbitration. In Preston v. Ferrer, the Supreme Court has ruled that states cannot impede the recourse to arbitration on public policy grounds. In other words, only the federal Congress has the authority to declare certain subjects not subject to arbitration. Even though the Robinson-Putnam Act is a federal law, today, virtually no federal statute limits the arbitrability of claims. Actually, in several decisions rendered by the United States Supreme Court, it has been declared that all claims arising under statutes promoting significant social interests have been found to be arbitrable. Therefore, the Robinson-Putnam Act, furthermore, the Robinson-Putnam Act does not contain a provision forbidding arbitration. Therefore, there is no legal impediment to subject allegations of impropriety under federal law, such as the one alleged on Jennings' claim, to submit the dispute to arbitration. Because 1, there is a contract which is valid and enforceable. 2, parties agree to binding arbitration, and neither one of the parties are contending these two subjects. And 3, the plaintiff has failed to prove that the dispute is outside of the scope of the arbitration clause, or that the precondition present was not satisfied. The defendant is asking this court to grant the motion to compel arbitration. Thank you.